Mr. Chairman, 23 members voted aye.
Thank you. The bill is reported without objection. The staff is authorized to make technical and conforming changes, and members will have 2 days to submit additional views.
Do you mind?
No. So to notice, I call up House Resolution 1455, directing the Attorney General to submit to the House of Representatives copies of certain communications related to certain recommendations regarding administration appointments, and move that it be reported adversely to the House. Without objection, the resolution is considered as read and open for amendment in any point. And on behalf of the chairman, I'll make the opening statement. This resolution was introduced by our ranking member, the gentleman from Texas, Mr. Smith, and referred to our committee. Although we have significant legislative business before us, under House rules, we are required to report this resolution within 14 days of its introduction, or a privileged motion to discharge the committee could be filed on the House floor. So we must put aside important legislative matters before us and address this resolution. And for 3 reasons, I recommend that we report it adversely. First, although there is no credible evidence that the Department of Justice had any involvement in or knowledge of any alleged offers to Representative Sestak or Mr. Romanoff, the Department has already responded to multiple inquiries from Republican members on this issue in letters of May 21st, June 14th, and June 15th. Attorney General Holder has responded to questions on the subject before this committee on May 13th. The Department has made it clear that any allegation of criminal conduct by public officials will be reviewed carefully by career prosecutors and law enforcement agents who will take any appropriate action. In addition, the White House counsel released a memo on May 28th describing what happened concerning Representative Sestak, and White House email to Mr. Romanoff has also been publicly released. Second, high-ranking Bush administration lawyers and others on both sides of the aisle agree that there is nothing illegal about offering a potential candidate for office an administration-appointed political position, even if partially motivated to avoid a divisive primary. For example, Stephen Bradbury, former Bush Assistant Attorney General in charge of the Office of Legal Counsel, acknowledged that there would be no criminal prosecution based on the conduct at issue here. Former Bush White House Ethics Advisor Richard Painter said on May 28 that, in light of the information released by the White House, it is even more apparent that this is a non-issue, no scandal, time to move on. Former DOJ Public Integrity Prosecutor Peter Zeidelberg, who once pursued charges against a top Hillary Clinton fundraiser, commented that you'd be laughed out of the courtroom for trying to prosecute the alleged conduct concerning Mr. Representative Sestak. Third, particularly in light of all of this, there is no proper basis for the resolution's specific document requests. There has been no indication that there was any guidance or recommendation from the Department to the White House in this matter, as in the first request. And if there's any new opened investigation or review by DOJ or the FBI as to the alleged improper conduct, the FBI has explained that it would contradict long-standing policy and jeopardize an investigation to either confirm or deny its existence. Providing all documents related to such an inquiry as demanded in the second request would be even worse. The Department has also explained the long history of career officials handling such matters professionally and independently without need for special counsel. Former Bush Attorney General Michael Murkowski, who did appoint a special prosecutor in the U.S. Attorney matter, has agreed that there is no basis for one here. Indeed, the Department of Justice Inspector General found the U.S. Attorney matter involved improper conduct concerning and by Department of Justice and improper political pressure on federal prosecutors. At its core, that investigation was about ensuring the proper functioning of the criminal justice system, none of which is involved here. For those reasons, I recommend that we report the resolution adversely to the House and return as expeditiously as we can to other important business before the committee. Now recognize the ranking member of the committee, the gentleman from Texas, Mr. Smith.
Thank you, Mr. Chairman. Today's resolution will help the President further his goal of increasing government's transparency and accountability. When President Obama was elected, he made grand promises of change in Washington. He claimed he would impose strong ethics standards on White House staff and promised to run the most open and transparent administration in American history. Unfortunately, the Obama administration has broken both of these promises. Rather than openness and transparency, the administration has engaged in regrettable backroom political deals. It has been 4 months since Congressman Joe Sestak disclosed that the Obama administration discussed with him a federal appointment in exchange for his dropping out of the Democratic primary for Senate in Pennsylvania. And it has been several weeks since Colorado House Speaker Andrew Romanoff disclosed he received a similar offer. It appears that administration officials may have engaged in an unethical and possibly illegal practice of manipulating Senate Democratic primary elections by offering candidates jobs in this administration. In the White House counsel's report released earlier this month, the administration admitted to making the offer to Sestak in an attempt to prevent a divisive primary that might have ended with a lost Democratic seat in the Congress. The President's political affiliation as a Democrat does not give administration officials carte blanche to do whatever they want simply because it benefits the Democratic Party. The most basic rule of American government is that no one, not even the administration, is above the law. Free, fair, and democratic elections are the cornerstone of our political system. Federal law protects fair elections by prohibiting government officials from using their positions of power to unduly influence election outcomes. It is a crime to offer someone a federal appointment as a reward for withdrawing from a primary election race. The Attorney General has a responsibility to ensure that all political officials, including administration officials, follow this law. The American people are not buying the administration's defense of everyone does it, or that's just how Washington works. Regardless of anyone else's behavior, President Obama made changing Washington the cornerstone of his campaign. Nobody asked him to promise open and transparent government, but when he did, Americans took his promises seriously. The resolution of inquiry we consider today directs Attorney General Holder to do what President Obama has failed to do for 4 months: transmit to Congress documents relating to the White House's potential illegal and unethical offers to Congressman Sestak and Speaker Romanoff. I am disappointed that this resolution of inquiry is even necessary, but the administration has ignored all efforts to conduct meaningful oversight. On June 8th, Mr. Sensenbrenner and I sent Attorney General Holder a letter asking for the documents we are now seeking by this resolution. And on Monday, Oversight and Government Reform Ranking Member Darrell Issa and I sent a letter to the White House highlighting a curious pattern of federal earmarks directed to congressional districts around the same time the representative decided not to run in the statewide Democratic Senate primary. If the administration has nothing to hide, why not provide Congress with the requested documents and restore integrity to our election process? It's time for the White House to make good on its promise of transparency and come clean about what other elections administration officials may have sought to influence. Mr. Chairman, I encourage my colleagues to support this resolution inquiry. Before I yield back, I'd like unanimous consent to put into the record the opening statement of our colleague Jim Sensenbrenner.
Without objection, so ordered. And without objection, other member statements will be included in the record. Are there any amendments? If there are no amendments, the question before us is the motion that the resolution be referred to the House adversely.
Mr. Chairman.
Gentleman from Virginia.
Chairman, I move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, I'm pleased to support this resolution of inquiry. Since the news of the Sestak and Romanoff scandals broke earlier this year, liberal commentators and media outlets have raised the argument that these sorts of offers happen all the time and that this is just, quote, business as usual, end quote. What they fail to admit is that business as usual is entirely incompatible with the change that this administration promised to bring to American politics. Change we can believe in, quote unquote, is a slogan that Americans became familiar with in 2008 and 2009 as this administration ran for office and began governing. Americans probably thought it referred to a promise to bring a new political culture to Washington. Obviously, they were mistaken. The reality is that this is not business as usual. Administrations in the past have relied on the wisdom of the American people to elect their leaders, not on powerful political interference in state primary races. But this administration is different. It passed a health care bill that reorganized 1/6 of the American economy and bailed out rich Wall Street banks. It should be no surprise, therefore, that the administration had to resort to highly unusual tactics to scratch the backs of those who scratched theirs. Supporters of the administration's actions with respect to the Sestak and Romanoff scandals must now make a choice. Do they continue to subscribe to the tired notion that this administration has brought change to Washington, or would they like to now admit that the administration is yet another reiteration of, quote, business as usual in Washington, D.C.? Mr. Chairman, the types of actions that are alleged regarding White House employees with regard to Democratic Senate primaries around the country is not business as usual. This committee should not acknowledge that it's business as usual and should go ahead and support this resolution of inquiry. The resolution of inquiry will deliver transparency about the Sestak and Romanoff scandals. This transparency is long overdue. I support the resolution and ask why anyone would not support providing for that kind of transparency when it comes to very serious allegations about wrongdoing in the White House. I yield back.
The gentleman's time has expired. Are there other amendments?
Mr. Chairman,
The gentleman from California is recognized.
I move to
For
strike the
amendment.
last word.
Gentleman's recognized.
Mr. Chairman, on May 28th, committee Republicans sent a letter requesting the FBI investigate the allegations regarding White House officials offering Rep. Joe Sestak a job. On June 8th, Ranking Member Smith and Sensenbrenner sent a letter to the Department of Justice requesting specific information to ensure Congress and the American public understand the DOJ's involvement in the Sestak and Romanoff matters. The responses from both the FBI and the DOJ, which did not address any of the serious issues raised in the letters, was disappointing at the very least. Although we can disagree about policy, we should all be able to agree that the Congress has not only the role, but a responsibility to oversee the FBI and DOJ. I would ask my colleagues to support this resolution to preserve congressional oversight of the administration. Thank you, Mr. Chairman. I yield back.
Are there other amendments?
Mr. Speaker,
Gentleman from Iowa, do you have an amendment?
I move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, I support the pending resolution of inquiry, which is directed at the most politicized Department of Justice in recent history. The Department of Justice and this administration have a history of operating on a partisan basis, which is why it's essential that this committee conduct meaningful, thorough, and effective oversight of the Department of Justice to prevent its becoming just a political arm of the Obama administration. This resolution of inquiry attempts to break the culture of secrecy at DOJ that we have become all too familiar with under the Obama administration. We have the Attorney General Holder criticizing Arizona's immigration law before he's even read the law. And we heard that before us in this very room, Mr. Chairman. And we have also the Civil Rights Division saying that the people of Kinston, North Carolina can't have nonpartisan elections on one of the clearest examples of this Department of Justice's politicization. It involves the mishandling of the new Black Panther case. In May of 2009, the Department of Justice made a sudden and still unexplained decision to abandon the case against the new Black Panther Party. that was the most open and shut case of voter intimidation in the history of America. It was on videotape. That's more open and shut than something that happened back post-Civil War. This case arose out of videos that show two members of the new Black Panther Party with billy clubs smacking them in their hands, clearly intimidating voters entering and exiting the polling location in Philadelphia on Election Day, and calling people crackers. None of the three original defendants in the case even bothered to show up to court. Thus, the court directed Department of Justice to file the necessary paperwork to proceed with a default judgment, which very likely would have resulted in an important victory for the Department of Justice's efforts to prevent voter intimidation. Rather than moving forward with the default judgment, the Department of Justice reversed course and inexplicably dropped its case against all but one of the defendants. And as for the remaining defendant, we know that the Department of Justice did not seek or obtain the maximum penalty associated with voter intimidation, despite the testimony under oath by Assistant Attorney General Thomas Perez before the Subcommittee on the Constitution. She stated that the maximum was sought and obtained, but the facts in the case demonstrate that only a narrow injunction was obtained against the defendant. After 6 months of trying to get answers from the Department of Justice about this case, Mr. Wolf, ranking member of the Department of Justice's Appropriations Subcommittee, introduced a resolution of inquiry that was referred to this committee. Republicans voted in favor of that resolution, but we were outvoted, and the truth about the new Black Panther Party case to this day remains an administration secret. I fear that the resolution we are considering today will meet the same fate as the new Black Panther Party resolution, the one I just mentioned. Americans will be left in the dark yet again, and the administration and Department of Justice will get away with another tag team effort to advance a highly political agenda. I strongly encourage my colleagues to vote yes on this resolution of inquiry and break the cycle of secret political decisions at the Department of Justice. The American people deserve the truth about the Sestak scandal, and they deserve to know how the Department of Justice may have advised the administration in dealing with the consequences. And Mr. Chairman, in the Kinston, North Carolina case, for example, the people of Kinston, North Carolina voted by 63.8 to 36.2 that they wanted nonpartisan elections. The Department of Justice made a political decision. Some would say a race-based decision, and I would agree with that. The same person that canceled the new Black Panthers investigation also is the one that canceled the will of the people in Kinston, North Carolina, and that is Loretta King. She said, and this is Kinston, North Carolina, removing the partisan queue in municipal elections will eliminate the single factor that allows black candidates to be elected to office. Voters base their choice more on race than political affiliation. I mean, this is it's an appalling decision on the part of Justice, part of the Department of Justice, not to mention that there's not one nickel or one man-hour invested in the investigation of the criminal enterprise known as Acorn, and yet we have the Department of Justice investigating Arizona, not having read the bill. Yes, we need approval on this resolution that's been offered by Mr. Smith. I support it. I ask unanimous consent to introduce into the record the letter from the Department of Justice that addresses the Kinston, North Carolina case, and I'd ask unanimous consent.
Is there objection? No objection, so ordered.
And then, Mr. Chairman, I appreciate your indulgence, and I would yield back the balance of my time.
The gentleman's time has expired. Are there other amendments?
Mr. Chairman.
Gentleman from Arizona.
Move to strike the last word.
Gentleman from Arizona is recognized for 5 minutes.
Well, thank you, Mr. Chairman. Mr. Chairman, I support the resolution of inquiry that we're considering today because it's an important effort to conduct meaningful oversight of the Department of Justice. And one of our primary roles as members of this committee is to ensure that the DOJ properly discharges its duties as the nation's law enforcement agency and that it not engage in political affairs at the direction of this administration. This committee has considered numerous resolutions of inquiry this Congress seeking documents from the DOJ. Unfortunately, those resolutions have repeatedly been reported unfavorably out of this committee. For example, Mr. Chairman, you'll recall that the committee Republicans introduced a resolution of inquiry in November of last year, trying to understand why this administration still has not developed a coherent policy for detaining, trying, and transferring terrorists at Guantanamo Bay. It is utterly irresponsible for the Justice Department to continue to cobble together an ad hoc approach to the nation's war on terrorism. That resolution was also voted down by this committee. As a result, this committee is left without credible evidence that DOJ has an effective anti-terrorism policy. And when the Obama administration's policy for dealing with terrorists is simply, quote, trust us, Americans cannot help but feel less safe. Similarly, our resolution of inquiry to obtain documents from the DOJ regarding its policy for providing Miranda warnings to our enemies captured on the battlefield was also reported unfavorably. And still, months after DOJ, under the Obama administration, announced that it would reconsider where to hold the trial of 9/11 mastermind Khalid Sheikh Mohammed, still DOJ has left Americans in the dark about where this trial will finally be held. In fact, Mr. Chairman, the Attorney General has even refused to rule out New York City. When might we expect this political hot-button issue to be finally made public? Political reports that advocates on both sides of the issue expect that the administration will hold off revealing its true intentions until after the November elections. Even Senator Durbin has conceded the expediency of delay. Quote, we have to resolve that Guantanamo issue at another time. Asked that if he meant a non-election year, Durbin replied, quote, well, perhaps it'll be easier. That's a pretty cynical view and very accurate, close quote. Mr. Chairman, if the administration is taking the same view, then the administration's lack of transparency is nothing less than playing politics with national security. We can all agree that the administration's first job is to protect the United States from threats, rather than shielding itself from the accountability of the voters. Ironically, as you can see on the monitors, had to wait for a moment to make sure you could see on the monitors, the homepage of the DOJ website proudly displays an initiative called, quote, Open Government at the Department of Justice. And when you click on that banner, Mr. Chairman, you'll learn that this initiative was undertaken pursuant to President Obama's Memorandum on Transparency and Open Government. But the facts show that the DOJ, under this administration, is anything but transparent. And I strongly encourage my colleagues to vote yes on this resolution of inquiry and break the cycle of secret political decisions at the Department of Justice. The American people deserve the truth about the Sestak scandal, and they deserve to know whether the DOJ, this agency responsible for enforcing the laws of this nation and for investigating these kinds of things, played a role in covering up the Sestak scandal. And with that, Mr. Chairman, I would yield back the balance of my time.
Gentleman's time has expired. Are there other amendments?
Mr. Chairman,
Gentleman from Florida, for which purpose do you seek recognition?
move to strike the last word.
Gentleman's recognized for 5 minutes.
Mr. Chairman, during the 2008 presidential election campaign, President Obama made transparency and open government priorities for his administration. In fact, the day after his inauguration, he issued a memorandum directing the heads of government agencies to make government more transparent and user-friendly. It is strange, therefore, that the American people had to learn of the secret offers to Congressman Joe Sestak and Colorado House Speaker Andrew Romanoff from them, and not from this most transparent administration. And here we are 4 months after Congressman Sestak disclosed the offer to the public, considering this resolution of inquiry. This resolution is necessary only because the administration has failed to live up to its promise of open government for 4 months. If this administration were serious about transparency, it would have already produced the documents to Congress relating to discussions of quid pro quo offers to Congressman Joe Sestak and Colorado House Speaker Andrew Romanoff. Instead, Congress is left having to ask for information from the Department of Justice. Let me further explain what transparency means to this administration. On May 28th, the administration issued a short 2-page memorandum after months of political pressure to provide details about the Sestak issue. Congressional leaders and the media asked for more details, but they were not provided. Because the memo raised more questions than it answered, on June 4th, the ranking member asked that the full Judiciary Committee hold a hearing to investigate these deals. That request was declined. Then on June 8th, the ranking member, Mr. Sensenbrenner, sent Attorney General Holder a letter informally asking for the documents we're now seeking by this resolution. Once again, the administration blocked Congress's oversight function and the constitutional system of checks and balances. Finally, last Sunday, the administration announced on a Sunday morning political television show that it would disclose no additional information on this matter. As a last resort, the American people have turned to this committee to give life to the transparency that this administration promised us. Therefore, I support this resolution. I yield back the balance of my time.
Gentleman's time has expired. Are there other amendments? For which purpose, gentleman from California?
Mr. Chairman, I move to strike the last
Gentleman's
word.
recognized for 5 minutes.
I join with the ranking member in believing that time has come to get answers from the administration on a number of troubling matters. Congressman Sestak has done nothing but tell us something that should never have happened. The administration, after 10 weeks of intense scrutiny and request by the press, issued a page-and-a-quarter statement that simply said there's nothing illegal or unethical. Mr. Chairman, the American people know that this business as usual, which is the defense, is unethical and wrong. Whether it is illegal or not is up to a legitimate inquiry into the facts. But the facts are not forthcoming, not in the case of Sestak, not in the case of Romanoff, not in the case of many other troubling events that we continue seeing going on in this administration's use of federal funds, potentially to clear fields to save tens of millions of dollars of political money. Mr. Chairman, since the days of Andrew Jackson, Congress has passed one after another strong laws to prevent simply campaigning based on payoffs if you're elected. We have additionally, under the Hatch Act, prohibited or put up the wall, if you will, of separation between government officials who are in fact political appointees and politics. The last administration was researched extensively for something as simple as firing their own appointees in order to replace them with other appointees. The chairman himself was very active in asking about the U.S. attorney firings and whether or not that was politically motivated, when, of course, no laws were broken. It is completely within the administration's right to hire and replace people that they appoint. And certainly today, this committee has a right to say, why is Rahm Emanuel still there when he used a yes, exactly. When he deceived and disguised his actions by using former President Clinton to offer something in order to clear the field, clearly showing that whatever he was offering and why he was offering it was something he did not want to have publicly disclosed. Congressman Sestak publicly disclosed it, or the administration would still be denying any and all wrongdoing. In the case of Colorado State Senator Romanoff, very clearly, if not for the emails, we would still have complete denial. So, Mr. Chairman, the time has come. So many months have passed since the first announcement in February. So many questions have been asked and none answered, not even by that 1.5 page, we did nothing wrong, or others saying it's business as usual, you didn't expect us to change everything. Mr. Chairman, I would ask that you favorably move this resolution and yield back the balance of my time.
Gentleman's time has expired. Are there other amendments?
Mr. Chairman, I move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, it doesn't take a lawyer or a judge to recognize that the administration's discussions about job offers with Representatives Sestak and Andrew Romanoff in an attempt to influence Senate Democratic primaries go against the spirit of federal laws designed to prohibit political officials from wrongfully influencing the election process. The Hatch Act prohibits federal employees from engaging in certain political activity. The Hatch Act was enacted to ensure that individuals entrusted with discharging a federal duty on behalf of the executive branch maintain a bright line separation between their jobs and political activities. Similarly, several provisions in Title 18, the Federal Criminal Code, clearly prohibit offering, giving, and taking anything of value in exchange for any political activity. In fact, it is some of these very same statutes that are currently at issue in the trial of President Obama's home state's former Governor Rod Blagojevich. Mr. Chairman, I do not know whether administration officials violated any federal law when they offered jobs to Congressman Sestak and Speaker Romanoff. but it is obvious that in doing so, the administration may have engaged in the type of behavior these statutes were designed to prohibit. I suspect the administration knows this. After all, what was the need for President Clinton to deliver the message to Congressman Sestak? Was it to ensure the administration would avoid any potential liability under the Hatch Act or Title 18? Ultimately, we all work for the American people. The salaries of federal employees, including those who work for the Obama administration, are paid by American taxpayers. We must remember that federal employees are paid to provide necessary government services to the American people who pay their salaries. Taxpayer dollars should never be used by politicians to further entrench their own partisan political interest. This resolution of inquiry will hopefully yield documents that reveal the truth about whether the administration violated federal law. That is why I strongly support this resolution of inquiry. Mr. Chairman, I yield back the balance of my time.
Gentleman's time has expired. Are there other amendments? Gentleman from Texas, Mr. Gomet. Recognized for 5 minutes for the purpose of striking the last word.
All right, thank you for the purpose of striking the last word. I do think this resolution is important. We have seen from this Justice Department over the last year and a half the way they handled the Black Panther voter situation, where you clearly, according to an African-American gentleman that was one of the original fighters for the civil rights movement in the 60s, give an affidavit, obviously under oath, saying it was the worst case of voter intimidation he had ever seen, more so than the 60s. And then, even though all the career people said they wanted to go forward, it was a lockdown case, this Justice Department runs in and drops everything but one of the defendants. They were on video. They had testimony, and they dropped it. So clearly this was more about partisan politics than it was about doing justice. We know that this weekend I saw a newspaper article that said that the 5 people involved in the 9/11 plotting, beginning with Khalid Sheikh Mohammed, had decided to plead guilty. They were going to waive all of their pleading rights. They were going to give up all future motions. They were just going to come in, waive everything, plead guilty. Unfortunately, that article was dated December 9th, 2008, and a month later, this so-called Department of Justice runs in and said, we're not going to let them plead guilty. We're going to move them to New York and make a circus out of this thing. That wasn't about justice. Justice was about to be done for the over 3,000 victims of 9/11. And so now the report this weekend is the decision may be put off until after the November elections. Gee, could that be about politics? It ought to be about justice. And then we find out that something we've been trying to get to the bottom of for quite some time, these offshore leases that were executed in 1998, 1999 under the Clinton administration, in which the price adjustment language, we were told in Natural Resources, was actually pulled out intentionally. The guy that prepares them said, hey, you're leaving out this language. He said, leave it out and leave out the addenda. That cost the federal treasury hundreds of millions, and now I'm told it's cost us billions of dollars that went to companies like British Petroleum. And one of the people we were told that was not interviewed was a person named Sylvia Baca, because, you know, she would left the government and was no longer in the government service, so the IG didn't investigate or question her. And now, guess what? She's back working for the Interior Department and works for the Mining Management, Minerals Management Service. And nobody, as I found out last week, has bothered to investigate that. It's cost us billions of dollars, and they intentionally pulled this language out, and now back working for the government, and we're not doing anything on investigating that. And then we got the Sestak situation. Never mind that he went to the Naval Academy and that there is an honor code there that he is supposed to, not just at the academy, but always state the full truth. Never mind that it's a violation of that honor code not to tell the full truth. but we've got a Justice Department that could investigate. Just give us the facts. Tell us what happened so we can put this behind us, because there is so much else at stake here. But if there's a crime being committed, we need to know what it is. And I would just simply submit that this really isn't justice. The victims of 9/11 have not gotten justice. Maybe we should change the name to from Department of Justice to Department of Partisan Politics Polluting the Process. I yield back.
Mr. Chairman. Mr. Chairman.
Are there other members? Gentlelady from
strike the
Texas?
last word.
Gentlelady recognized, strike the last word, 5 minutes.
Mr. Chairman, I recognize that we're on a particular resolution, and I just hope that my good friend from Texas has gotten everything that has ever bothered him off of his chest, because that's what his previous statement evidenced. If we begin to talk about politicizing the DOJ, there are many examples of that in the previous administration. But what I would like to say is that on the issue at hand, particularly dealing with Admiral Sestak, former Congressman Sestak, if they will look at the materials submitted to this committee and various letters that have been written, particularly by their own colleague, the ranking member on the Government Reform Committee, these have been asked and answered. And all of this today is, again, a gripe session. The Department of Justice is not politicized. The Attorney General is not politicized. I've not seen him go in the dark of night and try to secure a signature of a sick and disabled person, nor has his staff sought to secure his signature on documents that would violate the Constitution while he was disabled. So we can begin to talk about what is politicized or not, but to the motion at hand, I would say to my colleagues that all that you have asked has already been given. This is not a motion that is to clarify. I believe it is simply to allow a song and verse gripe session. For that reason, I think that we should oppose this amendment and begin to move forward on legislation that will improve the conditions of Americans.
Will the gentlelady yield? Will the gentlelady yield?
I'll yield to the gentleman.
I don't know if this surprised you or not, but I completely agree with you how entirely inappropriate that was to go into ICU and try to get a signature. I agree. Any kind of politics is completely inappropriate. I agree with the gentlelady on that.
Thank you. Reclaiming my time, and I thank the gentleman for his courtesies and honesty on some of my comments, and I'd ask that we could work together and secure any material that we would need from the Department of Justice without this form of a resolution. I would yield back and ask my colleagues to oppose this resolution. Thank you.
Mr. Chairman. Does the gentlelady yield back?
Yielding back. Thank you.
Gentlelady's time has expired. Are there other amendments? Chairman. Gentleman seek to strike the last word.
Move strike the last word, Mr. Chairman.
Recognized for 5 minutes.
I thank the Chairman. Mr. Chairman, immediately after Congressman Sestak disclosed that on February 18th, the administration had approached him with a job offer to clear the presidential Democratic Senate primary for Senator Arlen Specter, Americans began demanding more information. They demanded it in February, March, April, and May, and as well as the present month of June. Mr. Chairman and colleagues, on Capitol Hill has observed much wrongdoing on the part of Democratic administrations and Republican administrations. Errors in judgment, even a commission of crime from time to time. And in those cases, it seems to me, if the alleged wrongdoers had simply come forward and said, fellow Americans, we blew it. I committed a crime, or I made an error in judgment. Forgive me, I'll try to do better. Americans, Mr. Chairman, generally are tolerant. Americans generally are a forgiving people, and I think this issue, this matter at hand now, needs for that sort of transparent foreclosure to come forward. Almost 4 months after Congressman Sestak's announcement, when the administration can no longer sweep its questionable conduct under the rug, it released a one-page memorandum on the subject. Unfortunately, that memo raised more questions than it answered. For example, the White House memo acknowledges that the Obama administration used former President Bill Clinton to discuss possible federal appointments with Congressman Sestak. The $64,000 question, Mr. Chairman and colleagues, is why? Why couldn't the Chief of Staff or even President Obama make this offer directly? Additionally, the White House memo confirmed that Congressman Sestak declined an offer to serve as an executive branch advisor while remaining a congressman. On May 28th, Mr. Sestak said he believed he was being offered a position on the President's Intelligence Advisory Board. There's only one small problem with the White House story. According to the White House own website, federal employees, not unlike Representative Sestak, are ineligible to serve on the President's Intelligence Advisory Board. Simply stated, the administration version of the events is implausible. Finally, the White House memo states that efforts, and I repeat, efforts in the plural, were made to determine whether Congressman Sestak was interested in a quid pro quo. Yet the memo describes only one conversation that Sestak had with the former President Clinton. What were the other efforts? Did any of these efforts violate federal criminal law or applicable ethical standards? President Obama promised the American people that the most transparent administration in history. Yet this administration's disclosure on the Sestak possible scandal is woefully inadequate. While circling the wagons may be good legal advice, it is oftentimes not good political advice. The public rightfully holds elected officials to a higher standard. To ignore this or somehow to argue that questions about this matter are without merit is an affront to the awesome responsibilities that we as elected officials hold in public office. The administration needs to come clean on this matter, clear the air. If laws were in fact violated, those matters can be addressed, but the bigger issue here is whether the administration is willing to hold itself to a higher standard. Ignoring this matter, this possible scandal, will only fan the fires. I encourage my colleagues to vote for the resolution, and I thank the chairman for having called this markup, and I yield back. But first, Mr. Chairman, I'd like to gain unanimous consent to have Congressman Chavitz's statement made a part of the record, and with that, I yield back.
Is there any objection? No objection, so ordered. A reporting quorum being present, without objection, the question is called. Without, the question is on reporting the resolution adversely to the House. Those in favor of reporting adversely, say aye.
Aye.
Those opposed, say no. The ayes have it, and the resolution is reported adversely.
Mr. Chairman.
Gentlelady from Texas.
Mr. Chairman, I wanted to...
Just a minute. Members will have 5 days to submit views. Gentlelady from Texas.
Mr. Chairman, I wanted to report for the record that I was unavoidably detained in a meeting discussing the jobs bill that has been stalled in the Senate that has been passed by the House. For that reason, I missed the final vote on H.R. 5503, Securing Protections for the Injured from Limitations on Liability Act. If I had been present, I would have voted aye and would like that to be placed appropriately in the record.
Mr. Chairman, may I ask unanimous consent to speak out of order?
I'm in the middle of...
Apparently, I'm sorry. I thought you had finished. I'm sorry.
No, and I asked unanimous consent for it to be placed appropriately in the record.
Without objection.
All right, excuse me. And the motion to authorize issuance of the subpoenas to BP America for documents regarding its claims process relating to the Gulf oil spill. If I had been present, I would have voted aye. I ask unanimous consent for it to be placed in the record.
Without objection.
And H.R. 5566, Prohibiting Interstate Commerce in Crushed Videos Act of 2010. If I had been present, I would have voted aye. Ask for it to be placed in the record. Ask unanimous consent.
Without objection. And I'd notify some of the members not to leave, Ms. Bowler, if possible.
And I thank the chair because of my being detained. Thank you. Yield back.
Mr. Chairman, I'll say it was my fault, but I don't believe the chairman heard me ask for a recorded vote, and I regret that I didn't make that clearer, but I do hope we will have a recorded vote.
We have members who've left. I don't know if we can get them back. If they'll hold the vote open.
Okay, we can hold the vote. We can hold the vote open.
Okay,
that's fine.
well, that's fine.
Without objection, the clerk will call the roll on the resolution 1455. Motion to report adversely.
Mr. Conyers, Mr. Berman, Mr. Boucher, Mr. Nadler, Mr. Scott. Mr. Scott votes aye. Mr. Watt, Ms. Lofgren. Ms. Lofgren votes aye. Ms. Jackson-Lee. Ms. Jackson-Lee votes aye. Ms. Wooters. Mr. Delahunt. Mr. Cohen. Mr. Cohen votes aye. Mr. Johnson. Mr. Johnson votes aye. Mr. Pierre-Louisi. Mr. Pierre-Louisi votes aye. Mr. Quigley. Mr. Quigley votes aye. Ms. Chu. Ms. Chu votes aye. Mr. Deutsch. Mr. Gutierrez. Ms. Baldwin. Ms. Baldwin votes aye. Mr. Gonzalez. Mr. Gonzalez votes aye. Mr. Weiner. Mr. Schiff. Mr. Schiff votes aye. Ms. Sanchez. Ms. Sanchez votes aye. Mr. Maffei. Mr. Polis. Mr. Smith. Mr. Smith votes no. Mr. Gutlatt. Mr. Gutlatt votes no. Mr. Sensenbrenner. Mr. Coble. Mr. Coble votes no. Mr. Gallagly. Mr. Gallagly votes no. Mr. Lundgren. Mr. Issa.
No.
Mr. Issa votes no. Mr. Forbes. Mr. King. Mr. King votes no. Mr. Franks. Mr. Franks votes no. Mr. Gomert. Mr. Jordan. Mr. Jordan votes no. Mr. Poe. Mr. Chaffetz. Mr. Rooney. Mr. Rooney votes no. Mr. Harper. Mr. Harper votes no. Mr. Deutsch. Mr. Deutsch votes aye. Mr. Gomert. Mr. Gomert votes no. Mr. Conyers. Mr. Conyers votes aye. Mr. Forbes. Mr. Forbes votes no. Mr. Berman. Mr. Berman votes aye.
The other members that want to have their votes recorded? If not, the clerk will report.
And then just adjourn. Well, we get, we have to read the boilerplate, right? I think they get the
Mr. Chairman, 15 members voted aye, 12 members voted nay.
15 voted aye, 12 voted nay. The ayes have it, and the resolution is ordered reported adversely. Members will have 2 days to submit additional views.